Listen up, because this just got real. A federal judge looked straight at the head of ICE and said, "Obey the law or face contempt." Not a warning, not a suggestion, a direct order. He didn't whisper it. He didn't hint. He put it in writing, summoned the acting director to his courtroom in person, and demanded an explanation for why ICE keeps ignoring court orders like they don't apply. That alone should stop everyone in their tracks. This is January 27th, 2026. Chief U.S. District Judge Patrick J. Schiltz, sitting in Minnesota, just dropped one of the most aggressive judicial orders we have seen against a federal law enforcement agency in years. He is demanding that acting ICE Director Todd Lyons appear in court on January 30th and personally explain why his agency has been blowing past court deadlines left and right. Not one or two cases, dozens. Schiltz did not sugarcoat it. He wrote, "This is one of dozens of court orders with which respondents have failed to comply in recent weeks. The court's patience is at an end." That sentence matters. Judges do not write like that casually. He called hauling the head of a federal agency into court an extraordinary step. Then he immediately justified it by saying, ICE's conduct was likewise extraordinary. In other words, this is not normal enforcement. This is not a paperwork dispute. This is the judiciary saying something has gone badly off the rails. And the threat was not abstract. Schiltz warned that if Lyons showed up without a satisfactory explanation, the court would consider personal contempt. That means fines, sanctions, potential detention, consequences aimed at the individual, not the institution. That is almost unheard of at this level. This was not a polite letter. This was a judicial gut punch. Then came the scramble. Just hours before the hearing was scheduled to happen, ICE suddenly released the detainee at the center of the case. The same detainee they had been holding in defiance of the court's order. No press conference, no explanation. Just a quiet release and transfer out of state. A panic move. The hearing was canceled. The director avoided the witness chair, but the damage was already done, because the precedent is now on the record. A federal judge forced ICE's hand by threatening personal accountability at the top. That alone changes the balance of power. This is what happens when you push the courts too far. So why did Judge Schiltz reach this breaking point? Because ICE's current enforcement surge is overwhelming the legal system and then disregarding it when it becomes inconvenient. Under the renewed immigration crackdown, ICE has deployed thousands of agents across multiple states, including Minnesota. Detentions have surged. Raids have intensified. Facilities are filling up fast. Supporters call it long overdue enforcement. Critics call it draconian. But even judges who stay neutral on policy are sounding the alarm on process. ICE is moving fast. Too fast. People are being detained without any functional plan for the legal obligations that follow. Habeas petitions, bond hearings, due process reviews. All of it is piling up, and ICE is failing to keep up or comply. Courts are issuing clear orders. Deadlines are being set, and ICE is missing them. That is not a policy disagreement. That is defiance. These are not newly arrived migrants picked up at the border. Many of these detainees have lived in the United States for decades. They work. They pay taxes. They raise children. Some have never been convicted of a crime, yet they are being held indefinitely. And when a federal judge orders ICE to provide a bond hearing within 7 days or release the person, ICE simply does nothing. That is what triggered this confrontation. Juan Tobay Robles is the case that brought everything into focus. He entered the United States illegally as a minor in 1999. He stayed. He built a life. He worked consistently. He paid taxes. He had no serious criminal history. During the recent surge, he was detained at Fort Snelling. He filed a habeas petition challenging his detention. On January 14th, Judge Schiltz ordered ICE to give Robles a bond hearing within 7 days or release him outright. That is not radical. That is basic due process, reinforced by Supreme Court precedent. The court has been clear for decades. You cannot hold people indefinitely without individualized review. ICE ignored the order. 7 days passed. Then more. No hearing. No justification. No communication. Robles stayed locked up. That is when Schultz escalated. He ordered ICE's director to appear personally or face contempt. And only then did ICE comply. Hours before the scheduled hearing, Robles was released and transferred to Texas. His attorney later described it plainly. A victory born of judicial pressure. But Robles is not an exception. Schultz made clear this is part of a pattern. Dozens of missed deadlines. Dozens of ignored orders. Families separated. People held for weeks or months without bond hearings. This is not bureaucratic delay. This is systemic stonewalling, and the consequences extend far beyond immigration. This case sits at the heart of the separation of powers. The executive branch enforces the law. That is undisputed. ICE operates under statutes passed by Congress and directives from the White House, but the judiciary exists to ensure enforcement does not trample constitutional rights. The Fifth Amendment guarantees due process. The Fourth Amendment protects against unlawful detention and search, and separation of powers means no branch gets to ignore another. When a federal agency treats court orders as optional, the system breaks. We have seen this clash before, during previous deportation surges, during family separation policies. Courts stepped in when enforcement crossed legal lines. What feels different now is the scale and the resistance. Judges are no longer issuing quiet reprimands. They are threatening contempt. They are targeting leadership. They are forcing compliance in real time. That is a warning shot. If contempt proceedings expand, we could see agency heads facing personal liability for institutional failures. That would be a seismic shift in how federal enforcement operates. Politically, the fallout is already building. Democrats are pushing for oversight investigations into systemic noncompliance. Republicans are defending the crackdown as necessary enforcement amid border chaos. But the optics are brutal, especially in Minnesota, where recent enforcement operations coincided with fatal shootings involving U.S. citizens Renee Good and Alex Pretty. Civil rights groups are linking those deaths to aggressive tactics and lack of accountability. Protests are growing again, outside federal buildings, in city streets, across social media. This is not fading. The broader consequences are serious. If judges continue imposing personal accountability, ICE operations could slow dramatically. Agents may hesitate. Detention numbers could fall. Enforcement priorities could shift under legal pressure. Or the administration could respond by escalating. Appeals, legislative changes, attempts to limit judicial oversight. Either path leads to deeper conflict. This is no longer just about immigration policy. It is about whether the rule of law still constrains power. One judge, one order, one summons that made the head of ICE flinch, one detainee released under pressure. But underneath it all is a system under stress, an executive branch pushing full throttle, a judiciary slamming the brakes, and real people caught in between, families, lives, liberty. The question now is simple. Does the law still mean something? Or does power get to ignore it? Because what happens next will shape far more than immigration enforcement. It will define who actually runs the system.